You can re-record your records right now. It's an 8-year statute of limitation on your records.
Yeah.
This
So-
is statute of limitation on music?
Yes.
This shit is criminal.
I just
Okay.
found it out. So,
Right.
so for instance, who gets your Super Thug shit forever?
Well, right now,
Epic.
they sold it to, no, it's Tommy Boy, they sold it to something.
All right, forget it. Let's just
Yeah.
use a random example.
Okay.
Let's just say I want to do Old Boy Over. I clear the sample and everything. I go record the record right now, put it out on streaming service, and tell niggas don't go to Def Jam to get it. I go get it to me right now, my bread.
But you
Everything.
re-recorded brand new.
I gotta re-record
with
it
your
brand
voice
new,
today.
everything.
But you let
Everything.
niggas know this is the new version of it.
Yeah, but
Okay.
you don't have to. You can say, because people gonna want to hear what they want to hear. You can record the exact same song you did today and put it out streaming because statute of limitation on the music, that how long they can actually own your shit.
Yeah,
And
they
we don't be knowing shit like this.
And
you
they're
get what
gonna
I'm
try
saying?
to get us right now.
Yeah, well, I'm
This
telling
shit you just said, this
Yo,
is
that- I
this
never
is
heard this
breaking-
either.
this is
I never
breaking
heard this
Illuminati
either.
rules. Let's keep going, man.
No, I'm
Come
just
on.
telling you, so you could go and record everything over
So
that
it's
you
8
want
years,
to.
you say?
Yeah, seven to eight. I go record the whole album, everything we did at Def Jam over, and steer my traffic this way to go get it. It's a lot of work. That's why the question he asks is like, you could go to the label, right, and be like, yo, what's up, the masters? You could give me at least 50%, 60%, or I could just go record this shit over.
So Cameron says that you got a statute of limitations of 7 to 8 years until an artist can re-record all of their songs to essentially own their masters. So let's discuss a little bit more detail, because what he's saying is partially true. So when it comes to, being able to re-record your songs, and that term that he uses, the statute of limitations, the statute of limitation is applied to a specific clause that's in the contract, and that clause has to do with how much time has to pass in order for the artist to be able to re-record their songs as they were in their original format from like a number of years ago, right? And a lot of times the way it flows is, for example, if the artist has a contract with the label that spans for 5 years, the clause will say after that contract is over, so after the 5 years, you have 4 more years after the contract is over until you can start re-recording anything from that 5-year contract. So if it's on the very first album you recorded, technically that's 9 years. If it's on the very last album you recorded with that label, which was in year 5, that's only 4 years. See what I'm saying? And the clause may be different. It may say that it's 7 years from the recording date. All of this has to be specified. So it's not like a law in Congress, at least from what I've been able to find. I'm not a music lawyer, but it doesn't seem to be a law in Congress that there's a statute of limitations of how long the label can own your masters, or how long the artist has to be able to re-record the masters. So it's not a federal law, it's a clause that's set in the contract, meaning that if the label puts in there that the artist can never re-record the original songs that they were on the album, that means you can never re-record it. And also the re-recording of it has nothing to do with ownership of the actual master in Taylor Swift's case, and also potentially in Cameron's case. Again, I don't know the details of his situation, but in Taylor Swift's case, label or the publishing company that Big Machine sold Taylor Swift masters to, they own that master to those songs forever until they sell them either back to Taylor Swift or to another company, right? So the master, again, has a separate clause. But if you re-record the masters, yes, you own a new master of it, a new master recording. Now, where it gets tricky is who actually owns the publishing, right? Because Cameron said in the video is that, if you want to spend the time and invest the time to re-record it, make sure you clear all the samples, make sure you get the same producers on board and able to negotiate a deal with them. All that has to be done just to own the master. Now, the producers that were on that track, now they know it's a huge track, they may be charging you astronomical amount of money just to be part of the record again. So that's something else you have to face with. One thing I also want to mention that you have to really consider is that it may create a race to the bottom. And let me tell you what I mean. Because yes, like Cameron said, you can get all the streaming money, and the streaming money, if your songs are going to be streamed for the next 50 years, that's a great chunk of money, and you want sort of the masters on there. But if you're already getting royalties anyways on the original masters that the label had with you, you're still going to get money for the next 50 years. But here's where it gets tricky, right? Let's say you recreate the recording of your own master. Another label still has the master record. If a motion picture wants to use Cameron's song or Taylor Swift's song, where do you think they're going to go to license the master record? Because they have two choices. They can either go to Taylor Swift or Cameron directly if they're loyal to that artist, or they can go to the original record company that owns the masters on it, because guess what? They're going to license that song to that movie, motion picture, or McDonald's commercial, or a BMW commercial for their cars much cheaper. You see what I'm saying? So the company like BMW, McDonald's, or motion picture, they get to now decide between two owners of the masters where they're going to go and license the song, because the initial or the original label that owns the master still has the right to license that master to anybody they want. And if this exists, if you got two, it's going to be a race to the bottom, because let's say they go to the label and the label's like, yeah, you can have this for $1,000 for your commercial, because Cameron told them, or Taylor Swift told them, you got to pay me $5,000. Again, where are they going to go? They're going to go to the record label that owns those masters. Otherwise, Cameron or Taylor Swift got to be like, nah, I'll give it to you for $500. See what I'm saying? So the streaming money, and again, what Cameron is saying, if you want to make the money off the streaming money, you got to do a lot of campaigns potentially to alert your fans to say, hey, I put out a new master, please go stream that one. Don't stream the one that was put out 7 years ago. The problem with that is, think about it this way. If a lot of your fans already have the original song added to their playlist now, let's say they have a favorite Cameron list from back in the day, right? And I have all those songs in there. Am I, as the consumer, going to take the initiative, or as a fan of Cameron, to really go back and try to find these 20 new songs that he recorded that are his, with the different color of the cover, artwork and all of that, just to support him? I might. If I'm a big enough fan, I might. But for you guys as artists or producers, you have to consider that. How much work is it going to take to reshift the demand of your newly re-recorded, masters back to your stuff? Because, in my opinion, Taylor Swift's fan base is a lot more loyal. It's almost like, Beyonce's Beehive. Taylor Swift has very, very dedicated fans. So she may benefit from this move a little bit better than Cameron. If Cameron doesn't do enough marketing or like a public campaign, to alert his fans that, yo, go stream my new record that came out in 2021, not the one that came out in 2011. That has to be done. And how much percentage of that streaming can you attain from that? So you got to consider all of this, and I just wanted to tell you guys all the information behind it. So again, it's a statute of limitation that's different for every contract. If the label decided to tell you that you can never record the songs, unfortunately, you're SOL. You're not going to be able to do it. And that was in the contract you signed it. That's why it's so important to read contracts and have 3 lawyers read it if you have to. And maybe not just music lawyers, but have a, M&A, mergers of acquisition lawyer to read it, have another business lawyer to read it, just so you have an intellectual property lawyer that doesn't even deal in the music industry, but they deal with intellectual property in the software industry or in, publishing books and things like that. Have different lawyers read it, especially if you get a massive contract, to make sure this little clause was not left out or said that you can never be recorded, because then you're in deep, trouble, basically. And let me tell you some other contracts, just so you understand that you could easily be put in the contract that you never can own this material or re-record it. For example, government contracts. When you're sworn to secrecy because you're working for the NSA or a Booz Allen or a Lockheed Martin, right, and you have a security clearance, if they want to put in that contract that you can never, ever talk about that particular project you're on until you die, you got to abide by that contract. Same thing with NDAs, non-disclosure agreements, especially when they settle in court. Let's say, the situation happened with Trump and the porn star. If they really had her sign an NDA that she can never talk about this again in her life, and they paid her $1 million for it, and she signed a non-disclosure agreement, she technically has to abide by that contract. If she breaks it, then really Donald Trump's team gets to sue the porn star for defamation or whatever they want. See what I'm saying? So what is written in the contract is the most important, and from what I've been able to find, there is no federal law that says after 8 years for any record label that the artist now has the freedom or the right in America to re-record their songs. It's the specific statute of limitations to that specific contract and to the specific clause of what it says and how it's structured. That's why I have to be very careful with reading this stuff. Again, if you were in my Indie Artist Accelerator, these are the topics we discuss all the time. We're actually going to do a class. I'm going to invite a music lawyer, but also another lawyer to sort of give both perspective on the music industry and what you got to think about. That's all, you can look forward to if you're a member of our accelerator. So make sure you check it out. But I'm going to leave you guys with that for now. Make sure you leave some questions and we can talk about this further. If I have any more information or if I find more information in the next couple of days, I will talk about it. But, put in the comments, share this video with any artist or producer or anybody in the music industry that needs to see this. And I will see you guys tomorrow as always for another day of Music Biz Daily, because the music business just doesn't stop, and it certainly doesn't stop changing and evolving. See you guys tomorrow. Peace.